The courtroom was colder than it should have been. Not by temperature, but by tone. Pam Bondi had entered prepared, professional, and above all, calm. She had learned long ago that in rooms like this, emotion was not protection. It was a weakness the system exploited. She wore black. No pattern. No jewelry. Just clarity. It was a federal hearing, procedural on paper, but political in truth. Pam had been assigned as lead counsel on a civil rights oversight case. Nothing flashy. Nothing scandalous. But it put her across the aisle from two judges whose reputations preceded them. Judge John Roberts. Chief Justice. Measured, methodical, and, when unprovoked, dangerously dismissive. Judge Amy Coney Barrett. Sharp, composed, and known in legal circles for her ability to dress down a witness without ever raising her voice. Pam was neither witness nor accused. But she had walked into their courtroom with evidence they did not expect. And what followed was not debate. It was performance. The hearing opened with civility. Formal acknowledgments. A brief outline of purpose. But it only took 1 minute for the tension to shift. Pam introduced her documentation. A quiet stack of case summaries and subpoenaed memos detailing procedural missteps in a recent appellate decision involving civil detainment practices. She read from them softly, carefully, without accusation. But Judge Roberts barely glanced at the material. He smiled faintly, not warmly. "Ms. Bondi," he said, his voice smooth. "You've brought us quite the binder. I almost mistook this for a press packet." A few light chuckles from the rear bench. Pam did not smile. She turned the page. "This document contains first-hand accounts from officers required to enforce policy later ruled unconstitutional." Judge Barrett interjected. "Ruled unconstitutional by whom?" Pam didn't blink. "By the 11th Circuit. 3 months ago. Unanimous opinion." Barrett raised an eyebrow. "And you believe this is relevant here?" "It's not a belief," Pam replied. "It's precedent." The room went still. But the judges were not impressed. Roberts leaned back. "Ms. Bondi, I'm sure you understand that federal court is not a classroom. You don't need to bring us homework to prove you've studied." It was meant to sting. Not enough to be considered misconduct. Just enough to dismiss her entirely. But Pam didn't retreat. She adjusted the binder. "Turn the next page." Her voice stayed steady. "I understand exactly where I am, Your Honor." That was the first moment the temperature in the room truly dropped. Because there was no anger in her voice. No defensiveness. Just gravity. And it disrupted something. Amy Barrett shifted in her chair. Then she smiled. It was the kind of smile women in power learn when surrounded by men who think condescension is invisible. She folded her hands. "Pam, if I may." Pam didn't flinch at the use of her first name. This courtroom is not the venue to relitigate political narratives. Pam closed the binder. Her hands rested on it lightly. This isn't a narrative. It's an account. And the only thing political is what happens when a legal standard gets ignored until it damages real people. Barrett didn't respond immediately. But Roberts did. He leaned forward. "Are you implying that this bench is complicit in some kind of systemic failure?" The room held its breath. Pam met his eyes. "No, Your Honor. I'm implying that systemic failure happens when people believe they're above accountability, even when they wear robes." The silence was absolute. Even the court clerk looked up. No one had raised their voice. No one had interrupted. But something had shifted in the air, something irreversible. Judge Roberts cleared his throat. "We're going to take a brief recess." But no one moved. Because the bailiff was already walking toward the bench. He wasn't moving quickly, just with purpose. Behind him, 2 federal agents entered quietly through the side door. And for the first time in Judge Roberts' career, he did not speak. Because one of the agents was carrying a sealed file with the Department of Justice insignia printed in red. The contents of that file would not be public for another 12 hours. But Pam already knew what it contained. She had submitted the supplemental material to the DOJ under sealed record 3 weeks ago. Because the evidence in her binder wasn't all she brought. There had been another set of files. Confidential communications between 2 seated judges and a third-party lobbyist tied to private detainment contractors. The emails weren't aggressive. They weren't even explicit. But they were enough. Enough to raise eyebrows. Enough to require review. And enough to trigger emergency protocol when the Office of Judicial Ethics received the final corroborating memo, sent anonymously, but verified twice. The agents moved to the bench without theatricality. One approached Judge Roberts. The other addressed Judge Barrett. Neither resisted. Because in federal court, resistance is not dramatic. It is career-ending. As the courtroom emptied, no one spoke to Pam. She gathered her binder slowly. She didn't smile. She didn't gloat. Because nothing about that moment felt like victory. It felt like proof. Proof that dignity, when preserved under pressure, speaks louder than any takedown ever could. And the only sound left in the courtroom was the soft closing of the door behind her. The federal holding facility was silent except for the rhythmic clicking of shoes on polished concrete. No cell doors slammed. No shouting. Just the steady sound of movement and consequence. Judge Roberts sat alone in an interview room. The fluorescent lights above him flickered faintly, as if even they were reluctant to stay on. His robe had been taken hours earlier. He now wore a plain suit, unadorned. His tie was gone. His cufflinks sat in a plastic tray outside the door, beside a signed chain of custody form. He hadn't spoken since the agents escorted him from the courtroom, not even when they read him the charges. He knew better than to speak. Across the hall, in a separate holding area, Judge Amy Coney Barrett sat with her hands folded. Her expression was controlled, her back straight, but the skin around her eyes had shifted. The mask was still on, but the strain was beginning to show. The allegations were not dramatic. They rarely were. The memo Pam Bondi had submitted did not accuse. It revealed dozens of calendar entries, private dinners, undisclosed meetings, and a single transfer from a Policy Institute's discretionary fund to a third-party shell organization, which had, according to records, made a last-minute donation to a campaign PAC tied to a congressional oversight committee. The trail wasn't just financial. It was directional, and it led back to one conclusion. Influence had been traded, not for cash, but for silence. When Pam Bondi had discovered the pattern, she hadn't celebrated. She had studied, quietly, for weeks. She verified each entry. She ran the donation dates against legislative calendar votes. She traced the Shell LLC's formation back to a paralegal who had once interned under Barrett. It was all there. But even then, Pam didn't go public. She went legal. She contacted a single liaison at the Office of Professional Responsibility. She submitted a confidential ethics alert. And then she waited. Because Pam knew something both judges had forgotten. Justice does not have to be loud to be final. That night, the DOJ issued an emergency bulletin confirming that both judges had been placed under formal investigation pending removal proceedings. It was the first time in over 30 years that two sitting federal judges were simultaneously detained on ethical misconduct charges. Cable news moved quickly, but the headlines got it wrong. They called it an ambush. They called it a scandal. They called it explosive. But it wasn't any of those things. It was quiet. It was methodical. It was earned. Pam Bondi did not grant interviews. She issued a single statement, 10 lines long. No adjectives. No retaliation. Just facts. But behind the scenes, something else was happening. Because once two judges fall, others start looking at their own files. Emails get deleted. Conversations stop mid-sentence. Memos that were once jokes suddenly look like liabilities. Pam didn't ask for any of that. She had done one thing. She had shown up with proof. And she hadn't flinched when they laughed. 1 week later, an interim hearing was held to determine judicial suspension. Pam was not required to attend. She did anyway. She sat quietly in the gallery as the acting justice read the findings. Violation of disclosure protocols. Breach of impartiality oath. Failure to recuse in cases of indirect conflict of interest. Each finding read like a sentence, even though no verdict had been issued yet. But it didn't have to be. The damage had been done. Not by a scandal, but by a file folder. Judge Roberts requested a written defense. It was 3 paragraphs long. Judge Barrett submitted hers by hand. But it did not contest the findings. It simply ended with a line most had never expected to read from her. I acknowledge the erosion of trust. It is not the accusation that destroys it. It is the avoidance. The room stayed silent after it was read. Pam stood and walked out. No cameras waited outside. No reporters. Only her car. She drove home alone. Not because she had won, but because she had done what the law asked of her. Even when it asked her to stand alone. That night, she sat in her kitchen and looked at the original binder, the one she had brought into court, the one they had mocked. She opened it to the first page. It was a quote taped into the margin, something her first mentor had once told her. It read, "They won't fear your evidence. They'll fear your composure." Pam closed the binder and went to bed. 3 months later, The robes were gone. Officially, the Judicial Council had not used the word removal. They had used its cousin, voluntary resignation under inquiry. But the law made no distinction. The outcome was the same. Judge Roberts had stepped down first. The press conference was short. He spoke of family, of fatigue, of the growing toll of public service. He thanked his colleagues and expressed regret that perception had been allowed to overtake performance. Pam watched from a side monitor in her office. She didn't comment. Judge Barrett released a written statement. There was no apology in it. But there was a sentence buried near the end that stood out to those who still paid attention to nuance. I entered the law to defend its clarity. Somewhere along the way, I mistook silence for neutrality. Pam read that line twice. Then she folded the statement and filed it in the same binder she had brought to court. The one they called a press packet. The one that changed everything. In the weeks that followed, other ripples formed. A mid-level ethics investigator was promoted. A new judicial transparency bill moved out of committee for the first time in 8 years. And a young clerk in Washington wrote Pam a letter. It arrived in a plain envelope. No signature. Just a note that read, "They tell us not to make noise. You reminded us we don't have to. We just have to stand still when others want us to vanish." Pam taped it beside her desk. She didn't reply. She didn't need to. Because she hadn't done any of this for praise. She had done it because once you see what power without scrutiny becomes, you don't get to unsee it. And once you understand that quiet complicity is how injustice survives in public view, you don't get to pretend it's someone else's job to challenge it. But perhaps the most telling moment came months later, during a symposium at Georgetown. Pam had been invited to speak. Not about the case. Not about the fallout. But about constitutional duty. Halfway through the event, a professor asked her a question that wasn't meant to sting, but carried weight. "Do you ever feel you were too aggressive?" Pam didn't blink. "No," she said. "Because I never raised my voice." There was a pause. Then silence. Because everyone in the room understood what she meant. Aggression isn't always volume. Sometimes it's resolve. And sometimes the most powerful confrontation doesn't sound like a takedown. It sounds like a woman refusing to lower her eyes. Refusing to back down when tradition expects obedience. And refusing to accept that dignity and disruption cannot share the same sentence. Pam never wrote a book. She never sold the story. She just kept showing up, binder in hand, voice steady. And the next time she walked into a courtroom, no one mistook her preparation for theater. Because by then, they understood something she had never needed to say out loud. That silence is not a lack of strength. And composure is not weakness. Sometimes, it is the reason justice finally has to listen.